Next, we're going to hear from Joe Rogoway. He represented my daughter in the case that made it happen to have her at school, so it's very dear to my heart. And we're hoping that that will help others in the state of California as well. But he's going to talk on legality of stuff when you're treating pediatrics.
Thanks, Jana. Thank you for having me. My name is Joe Rogoway. I'm an attorney in this space, and my office helped Jana and Brooke. For me, cannabis is something that is incredibly personal. I have been a patient since 1997, and it was really important for me when I was dealing with a lot of sports injuries to deal with Vioxx, Vicodin, Valium, a whole bunch of other nasty things, and cannabis replaced all that for me. And so when I went to law school with the intentionality of helping people in the cannabis, with cannabis before there was a cannabis industry. Earlier in my career, I did a lot of criminal work. I was a public defender up in Mendocino County, did all of the marijuana cases for the Mendocino County Public Defender's Office, was a public defender in Sonoma County, opened up my own practice in 2011, and did basically exclusive cannabis criminal defense work. And I represented, unfortunately, during all of that, a lot of parents who were either accused of endangerment just by having cannabis sort of accessible to their children because the parents were patients and or cultivators, or through actual provision of cannabis to their children that was criminalized. And one of the things I think is really important for everybody to remember is that notwithstanding Prop 64 and notwithstanding adult use legalization and your ability to go to a retailer and to get cannabis and cannabis products, it's still really, really important for you to get a recommendation for your child if your child is being treated. And that's one of the things I think is really easy to overlook, is with all of the new laws and all of the new protections that you have as adults, those don't carry through with adults providing cannabis to children, even if it's really, really valid. If you are not a caregiver, if the child is not a patient. And so that's a really important thing that I thought it would be important to just sort of state and restate here today. A year ago is when we had the case with Brooke, and that's something that was just incredibly personally and professionally validating to participate, to be a participant on. Everyone in my office wanted the opportunity to work on that case. It was a pro bono matter, so they were all kind of putting billed work aside just to help Jana and Brooke and their family out. And it's something that was a really intensive process where at times the school district was sort of on our side with things, would give us responses of, we want to make sure that Brooke is getting the treatment that she needs, but she just can't do that here at school. And essentially what the issue was is that the school district was not going to allow Brooke to attend school and also use her life-saving medical cannabis treatment. And so that was something that was obviously a non-starter for us. Dr. Goldstein was really helpful in providing declarations there, and it was through the help of her treaters, of the people at Brookes Preschool, Jana took the stand as well, that were just critical for the court to make its determination that the school district was wrong. And one of the things, and some of you may have been there for that hearing, one of the things that was really pivotal during the course of the hearing, the determinative hearing for whether or not Brooke was going to be able to both go to school and have her life-saving cannabis treatment, was the assistant superintendent for the school district basically said that it is a good alternative for Brooke to get the type of socialization that she would otherwise get at school with other 5-year-olds in the same way that my 5-year-old gets to hang out with other kindergartners at his school. The alternative for that is just if Jana would just arrange some play dates with kids in the neighborhood, and they could just come over and hang out. And that's basically the same thing. And then she can maybe Brooke can get up to an hour's worth of education a day, and that's basically good enough. And everything was fairly amicable up until that point in the hearing. And then when the assistant superintendent provided that testimony, I provided her with the cross-examination that she did not want. And that's where things, I think, really changed during the course of the hearing. And we really started to hit home for the court why the school district's position was just clearly preposterous. That you can't have a replacement for the experience that we all ourselves received in school, or our children's receive in school, by having someone at home, a parent arranging a play date with random kids in the neighborhood or something like that. And so we finished the hearing. The court issued a written ruling weeks after. And the written ruling not only included all of the points that we made during the course of our litigation, but the judge added a bunch of stuff. And it was a bunch of stuff that was really good for us and really bad for the school district. And it was like a 21-page written opinion. And it was profound. And basically, the judge just excoriated the school district. And in this opinion, that was such a clear validation of everything that Jana was trying to achieve, and such a validation of what many of you know and why you're here today. That is now something that is used fairly widely in the special education realm. One of the associates in my office who was working on that matter, this affected her so much that she actually went full-time into special education law. And her whole professional life now is dealing with helping kids navigate the system, which is a terrible system. If any of you have to navigate through the IEP process, it's terrible. It's terrible. And so one of the things that was really exciting for me is just yesterday, this associate texted me from the special education conference that she was at that has nothing to do with cannabis, that our case, Jana's case, is now being cited to attorneys that just do special education law for the proposition that the IEP that was offered in that case was inadequate, and that the school district did not offer a FAPE, which is what they have to do. And that now is at least advisory. It's not controlling, unfortunately, but it's advisory, and it's something that is used to teach other attorneys about this area of law. And it's something that also has been integrated in sort of without litigation into other school districts. It's a thing that I've heard about school districts adopting policies that allow for children now to be able to use medical cannabis on school grounds. And this boogeyman of like federal drug-free school zones or anything like that now seems to be less of a justification for them to prevent children from going to school and using medical cannabis. The applause really should be, though, for Jana. It really, for me, it was easy. For me, I didn't have to put myself out there in a way that was uncomfortable at all. This is very much well within my comfort zone, and happy to be a champion for this cause. It's different being a parent, and it's different putting yourself out there as a parent because of the risks and biases that are associated with that. And that as we hear about being a parent and experimenting with other types of medications, getting a prescription for Concerta is easy. Going and getting a tincture that has cannabinoids in it can be difficult. And it is a concern that you have that goes down to the very core of you as a parent and being able to parent. That is the government going to prevent me from being a parent because of that? Are they going to take my child away? Am I going to have to go through this process and this system only because I want to have my child have a better life? And so I guess just in closing, what I'll say is that for any of you that have children that are in this situation, first, if you have a problem that is similar to the type that that I dealt with on behalf of Jana and Brooke. I'm happy to talk to you. We do pro bono for this type of work, and I'm happy to have a conversation with you about that. Better yet, mitigate that liability ahead of time. So if you have a need, if your child has a need, and it's something that you don't yet have a doctor's recommendation for, get that doctor's recommendation in hand, because that is pivotal in terms of the legal analysis to protect your rights as well as your children. Thank you very much. Yeah, so a recommendation is where you go to the physician. It's different than a prescription, and basically under state law, it's just a recommendation or an approval. So if you went to a doctor at the very sort of de minimis level, if you say, this is what I'm using as a treatment, and the doctor says, yeah, that's okay, that's an approval. So that's the least of which is required. Otherwise, the recommendation is basically sort of tantamount to what a prescription would be, although prescriptions are illegal federally because it's a Schedule I controlled substance. You can't prescribe it. It's only subject to recommendation, but then you take that recommendation, you supply that to the state of California, you get your ID card, and that's a process that you go through. It's cleaner that way because you have this prima facie document. It's also easier if you need for evidentiary purposes because you can get it admitted into evidence as a government record instead of having to go through like a subpoena duces taken process that requires testimony or at least a declaration, if you're lucky, on behalf of the physician. So the easiest thing to do is to get that state ID card, and that's usually something that if you kind of badge that to law enforcement, that oftentimes will sort of end that interaction just more cleanly and more quickly than with a doctor's recommendation. And there's always sort of the skepticism amongst law enforcement that the recommendation itself could be a forged document because it's not a formalized appearing document oftentimes. And so it's just cleaner if you have the state ID card. Although there are reasons why people opt not to have a state ID card because they want to avoid sort of formally being into the system. Yeah, please.
So with the state issued, isn't there also a reduction in the taxes that you pay?
Correct. Yeah, that's right. Yes.
Is that the patient gets the card or the caregiver gets the card?
Both. Yeah. If you're getting it on behalf of your child, then you would get one as a caregiver, which would allow you to go to the retailer and to purchase it on behalf of the patient, your child. Yes. Pro bono within reason. Yes, 20,000 pro bono cases might be a bit much, but I'm happy to talk to you about it. I mean, it's something that is really important to me on a personal, professional level. It's something that, as a firm, is a part of our sort of culture and our value system. So whatever issues come up, please just give me a call. Happy to talk about it. Great. All right. Thank you very much.